every speaker that this is the most registered to kind of make the speakers a little nervous or something, but I'm going to apologize for a couple things. First, for you to have to hear a securities lawyer drone on Friday morning, I apologize. The second, I don't have a deck. When I used to do these talks, I had these decks where I had lots of rules in writing, nobody read it. And then I read a book, I think, called The Zen of Presentation, and my deck slowly whittled down to just a few words, and now I've reached the ultimate where I don't have a deck anymore. All right, I'm going to jump right into it because your sponsors at Innovate Pasadena and here across campus have given me a tall order. They've asked me to share with you in the next, I think, or a little less than half an hour, the types of financing methods under the new Jobs Act, who you need to hire and roughly what the cost will be under each of these methods. And then what I'm going to do is I'm going to give you the 10 steps beginning today for the new crowdfunding rules, what you need to do and what you will be doing if you do a crowdfunding campaign under the new crowdfunding rules. And then we're going to have Q&A. All right, so let me tell you a little bit about why this is so exciting. I think probably most of you know, and I assume that's why you're here. In May, on May 16th, the SEC's long-awaited rules for equity crowdfunding under Title III of the Jobs Act takes effect. People have been waiting for 3 years since the enactment of the Jobs Act in 2012 for these rules. And for me, a securities lawyer, and this is all I do, I've done this for 30 years, May 16th is going to make securities law history, hopefully in a good way. It is historic because for the first time since we've had federal regulation of securities in this country, and when I say securities, I mean OPM, taking other people's money. For the first time, entrepreneurs will be able to raise money from the public, from non-accredited, even unsophisticated investors, without registering the offering with the SEC. Now, registration with the SEC is a very expensive process. That's the process by which companies do IPOs. And as you all know, today the capital markets are such that the IPO market, the public equity markets, are relegated to really large companies, unicorns. And the costs of doing an IPO, registering with the SEC, literally is over $1 million in most cases when you include the legal and accounting. Back when I was with the SEC for 8 years, a long time ago, and when I left the SEC 20 years ago, there were a lot of small regional investment banking firms underwriting small IPOs, $10 million IPOs. Well, after the bust, the dot-com bust, those regional investment banking firms went away. And so the only IPOs that you have are these very large ones. So Congress recognized, number one, that we need to get capital in the hands of earlier stage companies because it was this capital gap. It was too difficult to raise capital under these old, outmoded rules that had been on the books since 1933. And basically the rule since then was, before the Jobs Act, you could not solicit the public for capital unless you registered with the SEC. And otherwise, there was an exemption called the private offering exemption from registration. The problem with the private offering exemption was the SEC had all this time interpreted private offering to mean pre-existing relationship with the prospective offerees. So you couldn't do any form of advertising. All right, well, fast forward 90 years, Congress, in recognition of the fact that there's an internet and we have modern communication technology, realized that it's impractical to prevent people from having a public presence. Now, why is it so important that we talk about this? Partly because what the Jobs Act did not change are those draconian laws regarding liabilities that are on the books still. You have to remember, in 1933, Congress is enacting these laws in response to the 29 crash, people jumping out of windows, the Great Depression. So there are very draconian laws on the books. And I don't want to go through the whole horrors, but in a nutshell, let me put it this way. The other day I was in a meeting with representing a group of doctors who invested in a startup. And doctors are the worst. They don't understand anything about an investment. So of course they're taking the position that they were misled about everything. So I'm in the meeting with the two young founders and their big law firm lawyer, and I'm asking the founders, did your lawyer tell you that the two of you can be individually, jointly, and severally liable for the full amount of not only my client's investment, but the full offering amount? And by joint and several, that means that if I go get a judgment against you, I can recover the full amount against either one of you. You have a cause of action against the other for contribution, but I can get a judgment for the full amount of the offering against either one of you. Your personal assets are at stake. And judgments in California are good for 10 years. And they earn post-judgment interest at 10% per year.
Nice.
So, and my clients are telling me, you're pretty bright and you may be the next Mark Zuckerberg. So if I get a judgment, even if you don't have any assets right now, I'm going to be looking over your shoulder for the next 10 years. Those liabilities are still on the books. And so that's the reason it's so important that we, follow the rules. Okay. The Jobs Act created 3 types of offering methods, and you've probably seen reference to them. One is under Title II. It's Regulation D, Rule 506C. Okay, the second is something called Regulation A or A+, and the third is Title III crowdfunding, which we're going to talk about this morning, and it takes effect in May. Okay, so all the crowdfunding that you see right now, equity crowdfunding, and again, we're talking about equity, not donation. Donation, if you don't get a security in exchange for your money, the securities laws don't apply. And so when we say security, we're talking about, the Supreme Court has long ago interpreted security to mean stocks, everything you think of, stocks, bonds, in most cases debt, including. So any kind of investment of money with an expectation of a return based on the managerial efforts of others is deemed to be a security. So if you're selling a security, that triggers all of these securities laws that we're talking about this morning. Okay, so the kind of equity crowdfunding that you see today, that's being done under this Regulation D, Rule 506C. That kind of crowdfunding only allows accredited investors to participate. And accredited investors are, in the case of individuals, people with $1 million in net worth, excluding their home equity. Before Dodd-Frank, you could include your home equity, but you have to exclude your home equity. Or if you make individually $200,000 in annual income, or joint with your spouse, $300,000. So if you meet those thresholds, you are an accredited investor. No sophistication requirement. SEC is talking about changing the definition of accredited investor, possibly to allow some sophisticated investors who don't meet those financial criteria, but I think we're a long way from that. Okay, so that's what you see now. So all Realty Mogul, AngelList, all of the crowdfunding sites that you see now are accredited investor offerings only. Now under Reg D of Rule 506, there's no offering limit, so they can raise, in theory, $100, $200, $500 million, $1 billion if they want. There's no offering limit. And there are very few other restrictions because the concept is if they're accredited, investors can fend for themselves. All right, the second type is Reg A+. Reg A+ requires you to qualify the offering with the SEC in a manner very similar to a registration of an IPO. So you have to file with the SEC your offering circular. The SEC reviews it, and then once they declare it effective, then you can go out with your offering. One of the more popular ones that you've seen is probably Elio Motors. They're doing a Reg A offering right now. One of the features of Reg A is that you can do something called test the waters. So if you followed Elio, you may have noticed that before they actually started selling the securities, they went online and they did a campaign and they said, if you're interested, we're going to be doing this Reg A offering. If you're interested, give me your email address and we'll send you information about it. And once you can reserve a spot. that's testing the water. So they were able to see in advance of getting qualified by the SEC, what kind of interest there was, whether it was worth spending the money to hire lawyers and accountants to file this stuff with the SEC. Okay, you can't do that, as we're going to talk about, under Title III crowdfunding. All right, so the third, let's get to that. The third method of raising early stage capital now is Title III crowdfunding. This is the crowdfunding that I mentioned in the beginning about that's going to take effect on May 16th. It allows you to take up to $1 million from anybody, provided that you meet these requirements. And we're going to go through the requirements, but I'm going to do it kind of in a chronological sequence by telling you the 10 things that I think you need to do starting from now in order to comply with these laws. Okay. Let me look at my list here. Okay, step number 1. You need to start your PR today. And the reason for that is because under Title III, unbeknownst to a lot of people, there is a restriction on general solicitation. This ridiculous restriction on general solicitation still applies in Title III. It does not apply in the Title II Reg D 506 offerings for accredited investors. So that's why you see advertisements all over the internet for current equity crowdfunding. Under Title III, there's a restriction on general solicitation. So how do you promote your offering? Well, one thing the SEC will allow you to do, the only thing they will allow you to do, is send out what they call a notice of your offering. It's kind of like if you see in the back of the Wall Street Journal is the tombstones. They will allow you to tell the public on your website, through emails, that you are doing an offering. They will only allow you a very brief description of the business you're in, like brief as in not more than a paragraph. And you can't talk about the terms of the offering. You can only direct the person to a website, to the portal. Okay, and we're going to talk about the portal in a minute. That's the only form of advertising and solicitation you can do. Now, the reason I say start your PR campaign now, you can't, when I say PR, I don't mean your social media campaign advertising the offering, because as I've just discussed, you can't do that. But you should start your public relations campaign. That is, getting information about your company and about the service in the marketplace now. And the reason for that is the SEC can take the position that if all of a sudden, once you start doing your PR campaign, coincidentally, right at the time you start your crowdfunding campaign after May, the SEC can take the position in a lot of cases on this. You're conditioning the market. You're in effect you're circumventing the no advertising rules, even though you're not talking about your offering. If all of a sudden you start, you hire a PR firm and they don't mention the offering, but all of a sudden you start issuing a ton of press releases and you have no history of releasing information publicly, or you just start your website like the week before you start your crowdfunding campaign, there's an argument that that is conditioning the market and that's advertising. So step number 1, start releasing information. Talk to a PR person, start your social media campaign now. Get information out there, not about the offering, but about your company. All right, step number 2, you have to select a portal. Under Title III, you have to go through a portal, and you can only use one. You can't use multiple portals. Now, there are 2 types of portals. One is a registered broker-dealer, and the second is something the SEC created, is just a registered portal that is not a broker-dealer. And the reason that's important is because broker-dealers are subject to very strict regulations by FINRA, the Financial Industry Regulatory Authority. So for example, broker-dealers, before they can recommend a security, your crowdfunding offering, to their customers on their website, they have to do a suitability analysis. They have to make a determination that that investment is suitable for that particular customer, and they have to do due diligence on the offering itself. It's a very expensive process, and that's part of the reason that you don't get broker-dealers underwriting smaller deals, because broker-dealers for that service can charge a commission, a transaction-based compensation. That is, they can charge a percentage of the raise. Portals cannot, because they're not broker-dealers. In order to charge and get a commission, you need to be registered as a broker-dealer. So the portals, so in recognition of the fact that portals can't charge a commission, the SEC said, okay, how are they going to make money? We will let them take a piece of the company. So the non-broker-dealer portals can take a percentage of your company, and they will. And we don't know what it remains to be seen what it will be, but I suspect it'll be somewhere between 5 and 10, maybe even 15%. Which, doesn't seem like a lot now, but, believe me, if you're successful, that's a lot of dilution. All right, so in selecting a portal, who do you decide to use? Well, as I mentioned, you can't do a general solicitation, but the SEC will allow you to communicate with the portal's registered user through any means of communication that the portals provide. So that's how you're going to conduct your campaigns. You're going to utilize the means of communication that the portal provides. And I think it remains to be seen. I think there's room for a lot of innovation here, because there are already a lot of portals. There are going to be a lot of crowdfunding portals, and there's going to be a lot of competition. And there's quite a bit of money going behind a lot of these, this whole fintech thing. So I think step number 2 is to really understand what that portal has to offer by way of communication technology. Also, how large is their registered user database, right? Because they're going to be able to, you will be able to, through the portal's communication technology, communicate with those registered users. But the portal is not going to be able to basically conduct an advertisement for you to promote to the general public. The only exception to that is you've probably seen some of these some of the like crowdfunder, they will occasionally do like the top deals, that are trending. And so the SEC is going to allow the portals to do some of that. And so with that one exception, the portal can't otherwise advertise to the general public your offering, and neither can you. But again, you can go through the portal's communication technologies. All right. All right, let me mention this issue about promoters and finders and transaction-based compensation. It's a big deal, because before the Jobs Act, I told you had to have a pre-existing relationship with your potential investors. And a lot of people tried to satisfy that requirement, entrepreneurs, by using finders. That is, people who would make introductions to potential investors. And for that service, they would charge a fee, a percentage of the investment. Well, the SEC really cracked down on that, because the finders are selling securities. And so those finders are supposed to be registered, and if there's not, there are serious consequences, not only to the person because he's not registered, but there are serious consequences to the company for using an unregistered finder. And one of those consequences is there's authority that the investor can exercise that draconian remedy that I was talking about and get his money back from any one of the controlling people of the issuer of the company. So the one area you have to be careful is that the SEC's rules will allow promoters to be paid to promote your offering with 2 requirements. One is that if the promotion has to be done on the portal, and number 2, you, the company, have to ensure that the promoter makes disclosure when he's promoting and communicating that he's being compensated for that service. So how do you do that? Well, if one of the portals, offers to provide a service for a fee to have people actually make calls, for example, or to post something for you, or to send out emails, You know, you need to have procedures in place where you're monitoring on an occasional basis to make sure that those emails or those calls, that the promoter is actually disclosing the compensation. It's called due diligence, and we're going to talk about, as I get further down, the reason that due diligence is so important. Okay, number 3, find the accountant, transfer agent, and lawyer. The first step is find the accountant, because if you're raising over 100,000, if you raise 100,000 or less, you don't have to have, your financial statements don't have to be reviewed by an accountant. They're self-certified. You, the officer, have to certify that they're true. But if you raise over 100,000, you have to have reviewed financial statements. In the original proposal, the SEC had proposed if you raise over 500,000, not only do they have to be reviewed, but they have to be audited. The SEC backed off on that because the audits, even though an audit for a newly formed company shouldn't be all that expensive, it's costly. But so the rule is if you raise over 100 up to $1 million, you have to get reviewed financial statements. Now, how much is a review going to cost? It's a little hard because, again, this is new territory. It's never been done before. The accountants that provide the review, they don't have to be registered with something called the PCOB, the Public Company Accounting Oversight Board. That is, they don't have to be kind of, quote, SEC certified accountants. Any CPA can perform this review. The question is, are the CPAs going to be willing to do that if their review is going to be used in an offering which is going out to potentially thousands of people? And the question is, how much are they going to charge? I would expect that the fees would be in the $10,000 to $30,000 range. And I say that because we've talked to accountants who have offered to do audits in Regulation A+ offerings for as little as $30,000. So I guess the lesson here is to shop, because it's a new service, and you really need to find out which accountants are really aggressive about pursuing this market. Transfer agent, you do have to hire a transfer agent. The transfer agent is just a company that takes care of recording all the information about the shareholders. They keep the record of who the shareholder is, all the records relating to the shareholder. Transfer agents are registered with the SEC. I imagine that the portals are going to have arrangements with transfer agents, so you probably can just wait until you find the portal, and the portal will put you in touch with the transfer agent. Lawyers, okay. So here's the big thing. The rules are not DIY, okay, and for the reasons that I told you, there's a lot of liabilities. But you don't have to hire an expensive lawyer for this kind of offering, especially if you are a startup, and there are not a whole lot of disclosure issues. So what do securities lawyers do in the offering? All right, remember I was telling you about those liabilities? You have liability, and it's almost strict liability. If I'm pursuing you as a plaintiff on behalf of investors, I don't have to show that you intended to defraud anybody. I don't have to show that you were reckless. I don't even have to show that you were negligent. Under these statutes in California, you're liable, subject to a due diligence defense, okay, which is an affirmative defense, meaning that you have to prove it. And so if you can prove in court that you had a reasonable basis for the statements after reasonable investigation, that's a defense. So what securities lawyers do is they help you establish that defense. So for a company that's doing an IPO, for example, we will sit there and go through exhaustive discussions with company management and look at all of the history of operations and make sure that everything that should be disclosed is disclosed. And what is required to be disclosed? All, quote, material information. What's material information? The Supreme Court has said material information is that which would be important to a reasonable investor in making an investment decision. Well, you don't need a securities lawyer necessarily to tell you what that is. I mean, as a rule of thumb, if it feels like something you don't want to tell them, that's probably something that's material. So this is, what we're talking about here is full disclosure and full transparency. And today, frankly, if you don't disclose something, you're going to lose credibility, right? And so, especially on a crowdfunding offering, where the crowd can out you, you better disclose everything, otherwise you're going to lose credibility and you're going to have liability. So, getting back to the lawyer, there are certain issues that you should have a lawyer look at. So, for example, the formation of the company. If you formed your company on LegalZoom, you better make sure that the company was formed properly, because if you're out there selling securities that don't exist, that's going to be a problem. But that kind of review shouldn't be an expensive review. Any general business lawyer, every business lawyer should understand formation of corporations. You don't have to come to a securities law expert to tell you if you formed your corporation properly. And they ought to be able to do that on a limited basis, a limited scope engagement. You ought to be able to go to them and say, look, I just need you to take a look at my incorporation and make sure I did it right. They don't have to counsel you on the offering, undertake to expose themselves to potential liability to your investors. So again, I think you need to talk to lawyers, talk to many of them, negotiate with them, and at this initial level, you should be able to do this relatively inexpensively. How much is it relatively inexpensive? It shouldn't cost you more than, say, $30,000 in legal fees. It should be substantially less, depending on whether you're able to, how much of the work you're able to do. Okay, step number 4, you have to decide on a target offering amount. The target offering amount is the minimum that you have to hit before you can break escrow or before you can have access to the funds. And the minimum amount is there because, of course, if it's too low or if you don't have a minimum, the earliest investors are going to be reluctant to put their money in. Because if you don't have a minimum and you can start spending the first investor's money in right off the bat, to pay your lawyers and accountants, the early investors are going to say, well, I want to wait until maybe you get some runway here and you raise some funds. So that's the reason that you have a minimum. You set a minimum, and you have to raise the minimum, and the money has to go in escrow until you hit the minimum. After you hit the minimum, you then have access to the funds. Okay, step number 5 is you should start drafting the offering circular now. And you need to, the SEC has Form C, which you're going to have to file with the SEC to initiate your crowdfunding offering. The platform will probably provide all of that to you. But take a look at it right now. It's out there on the web right now. Because on Form C, the SEC has a Q&A format, which you can use as an offering circular. You can just simply insert the answers and distribute that to your investors. It's got all the information that is generally required in a securities offering. But the format of it, you're probably going to want to use a format of it that looks a lot more like a prospectus in a public offering. So if you're not familiar, if you haven't seen very many prospectuses in public offerings or private offering disclosure documents called private placement memoranda or PPMs, all you have to do is go to the SEC's EDGAR website, look at the IPO prospectuses filed on Form S1 for any IPO company that you know about, and look at the format, look at the type of disclosure that they're making. And that's probably the format that you're going to want to follow. There's a summary, there's a bunch of risk factors, there's a description of the company, description of management, principal shareholders table. So that's probably the format you're going to want to use because most investors are accustomed to seeing offering circulars in that format. Okay, one of the most important disclosure items is the use of proceeds. And this is where looking at the prospectus won't help you because in those offerings where they're raising $100 million, sometimes certain items in working capital are not going to be material. So you'll see in the use of proceeds section, general working capital. Well, in your offering circular, since you're only raising $1 million, you're going to want to break out in a fair amount of detail how you're going to use that money in the use of proceeds section. So if you're going to use it for advertising expenses, you're going to use it for salaries, you should break that out. And you won't see it broken out in a large offering because those smaller amounts are just not material. There's a related parties requirement. The requirement is if you, the company, engages in a transaction with a related party, an officer, director, family member, and some sort of you have some sort of transaction with them, and the amount exceeds 5% of the proceeds of the offering, then you've got to disclose it. And my recommendation is disclose any related party transaction, even if it doesn't amount to 5% of the offering. Again, transparency. If you have any related party transactions, you got to disclose it. All right, I'm going to go through quickly the last 5, because I think I have 2 minutes. All right. And actually the rest of it is pretty simple, because the rest of it, the portal will presumably walk you through. Because the next step 6 is filing it with the SEC. The portal will do that. You will do that with the portal. Number 7, you have to give progress updates within 5 business days of hitting 50% of your minimum. You have to post a notice to that effect. Again, the portal is going to help you do that. Step number 8, you have to consider amending the Form C that you file. If something changes materially during the course of your offering before you raise the money, and you need to make disclosure to investors about it, there's a procedure to amend the offering circular, and again, the portals will make sure that you do that. Next 9 is close. After you hit your minimum, you close, you take the money. And then 10 is there's an ongoing reporting requirement. 120 days, basically at the end of April, at the end of the year, you have to provide the same information that you provided to the investors in the offering circular, but you don't have to include the review. And so you just include your financial statements as of the end of the year, and you have to file that at the end of the year, 120 days after the end of the year. So by the end of April, you have to file that. All you have to do is post it on your website. Okay, step number 11 that I have to get in is a legal publisher, Thomson Reuters, asked me to write a guide on this. And so it's just published. It's called the SEC, A Practical Guide to the SEC's Crowdfunding Rules. And in it, I try to identify those issues where I think you should talk to a lawyer. It includes all of the rules that are relevant. And so if you're into reading rules, and I recommend you do, the book has just compiled all the rules. And there's some practical tips. And I'd be happy to answer your questions.
Thanks, Juan. So we're going to open up the Q&A right now. The general format remains, which is if you have questions, ask them. We'll walk around with the mic and make sure that you can voice them. If you want to share stories or have some comments about the presentation, please take it offline. Mark, will you be sticking around a little bit after the presentation is over?
I will.
Okay, cool. So if you have any questions that aren't addressed, if we don't have time for them, please keep that in mind and you can talk to them offline as well. Here you go, John.
So under these new rulings, what's the maximum that you can raise, and then how many times can you raise? Like in the
yes, right. Okay, you can raise up to $1 million in any 12-month period. And there are caps on the investment caps on the amount that the individual investors can invest. There's this $100,000 threshold. So if the investor has annual income over 100 and has net worth, again excluding home equity, over 100,000, they can invest up to 10% of the lesser of their 10% of their income or 10% of their net worth up to $100,000. Now, if they don't meet that 100,000 threshold, they're basically limited to, I think it's 2,000. It's 5%. The greater, I think it's the greater of 5% or $2,000. Yes.
Can you recommend a couple of portals that you just mentioned that we should look into?
You know, I would, Kickstarter hasn't yet decided whether they're going to even offer equity crowdfunding. So I would start with the portals that are doing equity crowdfunding. So Crowdfunder is one, Start Engine, these are both of these guys are in LA. So, you know, it'd be good to support local guys. Start Engine is another. Start Engine is doing the Elio Motors campaign, so they've gotten a lot of publicity. But my recommendation would be just to, you know, scour the web and see who's coming up as crowdfunding, equity crowdfunding sites, and interview them.
Back here.
All right, so I had a question in regards to funding portal compensation.
Yes.
So you mentioned that you can actually get security as compensation for crowdfunding. Now, are you allowed to take up a straight up fee, not based on how much you crowdfund, and also the rights and warrants of the securities that you receive in exchange for being on the portal? It has to be the exact same as whatever is offered to the investors.
Yeah, that's a good question. So, yeah, the answer is yes. The portal can just charge a flat fee, a dollar fee. If they're not a registered broker-dealer, and I suspect most of the portals, well, many of them are affiliating with broker-dealers, but the ones that aren't, they cannot take a commission. It can't be based on the success of the offering, so they can charge a flat fee up front. And the question of whether the terms of the securities being offered to the investors in the crowdfunding offer can be the same as those offered to other investors is a little bit more complicated. That's one where you probably need to talk to a lawyer. The basic issue is integration, and whether you need, they're going to be considered two separate offerings. And the question is whether you have to integrate those two offerings so that the rules for crowdfunding apply to both of the offerings. And the short answer is the SEC has tried to allow you to do that. That is, they've tried to allow you to do a separate offering under different conditions, so alongside of your crowdfunding offering, but you have to be careful because a lot of times the separate offering will not allow you to do a general solicitation. And so that's where you can get into trouble.
Back here.
Yes?
Mark, could you just summarize the rules for the, I'm not sure what the right word is, the non-dilutive, non-equity crowdfunding?
Yeah, for non-equity, so non-equity, there are no securities law rules. The securities laws don't apply. If all you're giving the so-called investor or the donor is a T-shirt, production credit in the case of a movie, in the case of Oculus, first right to buy the glasses. There are kind of Federal Trade Commission rules relating to general advertising that apply, but there are no securities laws that apply. And so it's not a very heavy regulated activity, non-equity crowdfunding.
Yeah, when do you think someone might consider the 506c raise instead of the crowdfunding?
Yeah, good question. So certainly if you need and can raise above $1 million, I think if you are confident that you can raise money from accredited investors only, one of the issues with 506c is in exchange for allowing you to do a general solicitation, the SEC is requiring that you verify that the investors that you take are accredited. And 506c has been around now since September of 2014. And so far the SEC's experience is that not many people are using it, partly because there's so much question and gray area about what's required to verify. Now there are third parties out there that will do it for a fee, and I've seen a lot of them that will do it for a very low fee. But the issue is that doesn't get you a pass. The issuer, the company, has to have a reasonable basis that if the third party is doing it, the third party is employing procedures that are adequate. And the remedies are very draconian if the procedures for verification are not followed. Because there's no, without going into a lot of the explanation about the securities laws, there's no fallback kind of safe harbor if you don't meet the requirements for that kind of offering. So I guess the short answer is, if you need to raise over $1 million, you can't use Title III. And if you're going to do a 506c public solicitation, you got to be very careful. There's another way to do it, which I won't get into, but that's to do it the old-fashioned way. Don't do a public solicitation and use a portal that has got that has kind of pre-vetted and qualified their investors. The SEC has recently come out with some interpretations about under what circumstances that will not constitute a general solicitation. So if you can meet those requirements, that is, don't do a general solicitation, then you're not subject to the verification requirement, and you can kind of rely on verifying the old-fashioned way, which was to send out a questionnaire and have the investor check the box that they're accredited. Yes.
How do you see this impacting the current investment infrastructure in the sense of friends and family rounds, seed rounds? How are investors in general reacting to this new investment vehicle?
Yeah, I think, it remains to be seen, but I think with the softening of valuations, and it's increasingly getting more difficult to raise seed rounds, as probably many of you have experienced, I think people are going to look more closely at the crowdfunding rules. They're not perfect. In fact, I've got a bill that's going to be introduced in a couple of weeks in the California legislature to create a California crowdfunding exemption that allows general solicitation. I think that's one of the problems of the Title III federal bill. But again, I think there's a lot of room for innovation. So I think a lot of these platforms are going to figure out innovative ways to help entrepreneurs get the word out to the crowd. When this first came out, I was talking, in fact, it was in Innovate Pasadena, and there was a VC on the panel, and I asked him, I said, people are saying that nobody's going to use this because nobody wants a cap table that's all junked up with all these shareholders. And his reaction was, the lawyers can handle that, which is true. The lawyers can figure out a way, to handle the investors. We were just talking about it this morning. In my experience with companies that have large numbers of investors, in that first few months, you almost have to hire a full-time person to answer their questions. But after that, they hardly get any more phone calls about it, especially if they're going to be small amounts of money that people are investing. So I don't think it's as much of an administrative burden as people realize.
All right, thank you so much for your questions.